what is Corporate Rescue Scheme or CRS? Corporate Rescue Scheme is a scheme of arrangement that allows financially problematic companies to restructure their debts and turn around their operation. In Malaysia, CRS is a mechanism provided under the Companies Act 2016 that facilitate the financially difficult firms to rehabilitate and restructure to liquidation. Now I will continue why and when a company needs Corporate Rescue Scheme or CRS under Company Act 2016. There is a lot of internal and external factors that can have disastrous effects on the company, such as fraud within organizations, economic downturns, pandemics, and many more. A company fortunes may then spiral downhill, making it impossible to get out from the quagmire. Rescue at this time may be very difficult. Liquidation may be the sole choice in the worst case situations. However, there is a way out to save all parties and stakeholders in this situation. So, this is when a company needs this scheme or Corporate Rescue Scheme, because Corporate Rescue Scheme is financially challenged company can be helped to rehabilitate, restructure their debts and provide alternatives to winding up. This scheme is also meant to bring down a number of companies from being closed down. This is important for all stakeholders of the company to be survived, and also for a country and the whole economy, because if many companies easily to winding up or bankrupt, it will be disastrous for the national economy. Now, I will continue to explain about legal provisions of Corporate Rescue Scheme. Legal provision for CRS can be found under Division 8 of Part 3 of the Company Act 2016 and the Company's Corporate Rescue Mechanisms Rule 2018, which come into force on March 2018. Under this provision, CRS divide into three arrangements. First, scheme of arrangement, second, corporate voluntary arrangement, and third, judicial management. First, the scheme of arrangement. Under Section 366 of the Company Act 2016 stated that court has the power to order arrangements or compromise with creditors, members or liquidators and contributors to form and approve debt restructuring arrangement. In other words, this provision allows the companies to restructure its debt with creditors. Court may order a meeting to be summoned in the way directed by the courts upon the applications of the company. And any creditor or member of the company, the liquidator if the business is wound up, or the judicial manager if the company is under judicial management. In the section also stated that the companies of arrangement can be approved by 75% majority of the total value of creditor that present and voting and approved by the court. Then all creditor, members and company are bound by it, or liquidator if the company is wound up. The second arrangement is Corporate Voluntary Arrangement or CVA. Corporate Voluntary Arrangement can be found under Subdivision 1 of Division 8 of the Company Act 2016. Stated that private limited companies are eligible to propose voluntary arrangement. A corporate voluntary arrangement is a method that permits a private companies to propose a voluntary arrangement to its creditor. The private companies must to be monitored by an independent insolvency practitioner who would make a report to the courts on the proposal feasibility. Corporate voluntary arrangements are a management-driven restructuring procedure that is swift a low cost with minimum court interventions. And lastly is Judicial Management or GM. Can be found under Subdivision 2 of Division 8 of the Company Act 2016, which state that a distressed company or its creditor can request for an order to be placed under the supervision of the qualified insolvency practitioner or judicial manager. A judicial manager job is to create and present a restructuring plans to creditors for approval. A corporation application for judicial management can be made by the company itself, or by the company director, or by the company creditor. The following are the factors that the court will examine for JM. First, the firm is unable to pay its debt or is likely to become unable to pay its obligation. And B, the company is unable to pay its debt or is likely to become unable to pay its debt. Thank you. That's all from me.
Thank you for your presentation. And now I will taking over this slide. Okay, firstly, what I will be explaining about the case law for CSR. We have taken the example of Kumpulan Leases SDN PhD, which is the one in liquidation, versus the Pembinaan Azam Jaya SDN PhD. On 4 February 2020, the employer in a construction contract had issued a statutory demand for winding up against its contractor. The demand was far more than 8.6 million, which was not based on a judgment sum. On 15 June, the employee petitioner filed the winding up petition against the contractor. This was on the ground that the contractor had repudiated the contract and there was an advance payment sum due to the employer. On 3 July, the contractor filed a judicial management application. The filing of judicial management would trigger a moratorium on legal proceedings. And then, on 13 October, the judicial management application was actually rejected or dismissed. And last but not least, on 18 November 2020, the High Court ordered the winding up of the contractor. The contractor appealed to the Court of Appeal. In this example, High Court decision, the Court of Appeal held that there were disputes on the debt. They are fighting among each other. The court also found that genuine and serious counterclaim raised by contractor against the petitioning employer. However, this case update will focus on certain aspects of the decision on the interaction between judicial management and winding up petition. Let's look at the implementation of the CRS. We have 3 implementation: scheme of arrangement, judicial management, and corporate voluntary arrangement. Okay, first, scheme of arrangement. A court-approved mechanism whereby a compromise or arrangement is proposed between a company in distress and its creditors to vary existing rights and obligations. This SOA application can be applied by either the company, members of the company creditors, a liquidator, or judicial manager. Under this framework, companies are allowed to apply a protection order or a restraining order to restrain any legal proceedings against the company. This will protect the company from creditor sanction to allow for successful restructuring of the company's debt. If this application is successful, a preliminary compromise or arrangement plan will be submitted. The court will then grant restraining order for an initial period of 3 months, which can be extended to until 9 months. For the next implementation is judicial management. This is a court-supervised corporate rescue mechanism for companies that are financially distressed but has a reasonable chance to be rehabilitated. A judicial manager will be appointed to manage the company's affairs, business and assets with a view towards rehabilitating, to explore whether a more advantageous realization can be achieved for all the stakeholders as opposed to a winding up exercise. This application under the judicial manager can be made by the company, by the director, or the company's creditor. Of course, they will have to discuss. Once the judicial manager has been made, it will be enforced in the period of 6 months and can be extended for another 6 months. During this time, there will also be a moratorium to prevent legal actions from being initiated against the respectable company. And then, within 60 days from the judicial manager order, judicial manager must present his proposal towards the creditors and obtain the approval of 75% of total value of the creditors in attendance and vote at the meeting. And last but not least, Corporate Voluntary Arrangement CVA allow cash-strapped private companies who have not created a charge over their assets, which will have opportunity to work out an amicable arrangement with their creditors. For example, rescheduling the debts with minimal court intervention. Here, the directors of the company will appoint a nominee, which is a qualified insolvency practitioner. Of course, it is important to be qualified insolvency to supervise the implementation of the Corporate Voluntary Arrangement (CVA) proposal to be voted on by the creditors. The effect of appointing a nominee and filing the necessary documents in court and through the Companies Commission Malaysia is an immediate 28-day moratorium to protect the company from any legal action against the company and its asset. It also restricts the landowner or landlords from exercising forfeiture. This proposal will require the approval of 75% of the total value of the creditors in attendance and vote at the meeting. And then, the CVA proposal will bind all the creditors to the company. Let's move on to the last slide, which is our CSR conclusion. As you can see in the picture, this is a two entity between the creditor and a cash-strapped company. Do you think that this is a very simple and clean? There will be a simple and clean process between these two. Of course, the creditor have their own interests, such as they want their profit, they want their interest, while the cash-strapped company just want to survive. So the creditor accounting profit has been roundly criticized for failing to address the wide range of stakeholders impacted by business bankruptcy. There is no consensus on how the insolvency system's different objectives should be handled and achieved, and no compromise on a working standard for determining priorities among them. That's all from us. Thank you.